Crime is wickedness. Crime is greed. Crime destroys families. Crime divides nations.
What is the duty of this court in the bail application? Am I understanding correctly? The question that needs to be answered by this court is there a case against the applicant? And if there is a case against the applicant, is there a risk if he is released on bail? Am I summarizing it correctly?
100% right. Will the accused stand trial?
Yes.
If bail is granted?
Yes.
Will the interest of justice?
That is part of it.
Will the interest of justice best be served constitutionally and in terms of the jurisprudence? It's quite a wide variety of factors that is expected from the applicants so as to help this court to arrive at a decision where the court can say, I'm satisfied, the interest of justice warrant or the interest of justice does not warrant.
And this court should be wary of not usurping the powers or the duties of the trial court.
Your Worship, in fact, that is my main submission in paragraph number 1, that in Van Wyk, obviously, the court held in Van Wyk, 2005, volume 1, SACR 41, SCA, paragraph 6, that bail proceedings are not to be viewed as a full dress rehearsal for the criminal trial. I fully agree with the court, hence I have cited that case as an introductory remark.
Hello, ladies and gentlemen. You are welcome to the channel. The magistrate reminded accused number 1's lawyer not to cross the boundaries by finding himself talking about the matters of the trial court during the bail application. The magistrate also wanted to understand from the lawyer of accused number 1 that, according to Dr. Moodley, the wife of accused number 1 consulted with a male claiming to be Lundoku Tlemkwanas, which is accused number 1. And at that time, accused number 1 was in prison. Is that not misleading the court? Accused number 1's lawyer said that maybe there was a miscommunication between himself and the wife. The defense did not want to dwell much on that point, and he was quick to say there is proof that his client is asthmatic, and if the court wants proof, the court can just write a letter to obtain the medical records. Accused number 2, he handed himself over to the police, so he is not a flight risk. Let me know on the comment section, do you think accused number 1 and 5 will be granted bail? Kindly watch the court proceedings and I'll see you on the next one. Danko.
But this information that applicant number 1, when he was at Westville prison, appeared before Dr. Moodley, what is it?
Your Worship,
because that is the impression created by the papers, and that is the impression which was given to Dr. Moodley. Dr. Moodley has since filed an affidavit to that effect, and he is referring to a person in front of him who was referred to as Lindo Buhle, but Mr. Mkwanas.
as court pleases. Your Worship, in the light of the fact that neither the state nor the court, in terms of section 60 subsection 3, ordered that the medical records from Westville be brought to court, in the light of the fact that in the replying affidavit, applicant number 1 takes this court into full confidence, saying, my legal team has attempted to procure the medical records from Westville to present them in court. However, Westville Hospital says, without the order of the court, they can't release those medical records. Therefore, the fact still remains, which is the subject matter of the submission, that applicant number 1 is a chronic asthmatic patient receiving medication at Westville Prison.
Mr. Lord, you are not the witness, you are not an accused person, so it would be unfair to subject you to cross-questioning, and I don't intend doing that. And I'm not doing that.
I fully understand, Your Worship. I fully
But the
understand.
question still remains, was it not misrepresentation that was made to Dr. Modley? That the person is Lindo Buhle Mkhwanazi.
Whereas in truth and fact, it's not.
Whereas in truth and in fact, that person was not Mr. Mkhwanazi, because at that point in time, Mr. Mkhwanazi was in Westville prison.
Your Worship, I fully, as an officer of the court, I fully concede on that aspect, Your Worship, except that the only submission will be, because at the end of the court, this honorable court will have to make a finding, is he a chronic asthmatic patient? In the absence of the evidence from the state, and his declaration is his replying affidavit, that whoever challenges that I'm receiving asthmatic medication from Westville, if the order is obtained, based on the order of the court, that information can be presented. So that information still, that fact still remains, Your Worship.
Thank you.
I am indebted to the court, Your Worship. Your Worship, one aspect, my apologies, one aspect being brought to my attention by my instructing attorney Dlamini is accused number 5 voluntarily handing himself over. That demeanor is not a demeanor of a person who is a flight risk. After the call through the mother had been received, he did a legal thing under the circumstances to get a lawyer, and the lawyer handed himself over to the police.
Ms. Gilling.
Ms. Gilling, who is in court. So the issue of flight risk, Your Worship, there is no objective, dependable evidence the state presented to substantiate that allegation.
And your submission, what is exceptional about him?
In the pot within which
that he presented himself.
Your Worship, in the pot within which this honorable court will be cooking that decision, whether or not exceptional circumstances exist, among other things, this honorable court to also consider the voluntary handing over to the police by the applicant.
Thank you.
As court pleases.
Okay.